smells like marijuana. What do you say? What should you do? Is there something you can do to protect yourself, and can you stop the cops from pulling this on you? Most people freeze. They panic. And in the moment of panic, they either say the wrong thing or they do the wrong thing that leads an officer to believe, you just gave me consent. And just like that, your Fourth Amendment rights vanish. In this video, I'm going to walk you through exactly what to say and what to do if you ever find yourself in this moment. From traffic stops to knock and talks to cops walking right up to you claiming they smell weed, I'm going to walk you through the exact phrases to say, the tricks and the traps cops will use in this situation, and the exact steps you can take to protect yourself and stand up for your rights. Let's start at the core of our constitutional rights. The Fourth Amendment to the United States Constitution says, and I quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." But what does that actually mean in real life? That means a cop can't just rummage through your pockets, your car, your home, or your property without a good reason. That reason is known legally as probable cause. But there are layers to this. Probable cause, that means an officer has enough clear facts in front of him to lead someone to reasonably believe that a crime is being committed. Think of probable cause as if you were to walk into your house, see smoke coming out of your kitchen, you have a good reason to believe there's a fire going on. Why? Because where there's smoke, there's usually fire. But what about the term people use, reasonable suspicion? This is a much lower bar. Cops only need reasonable suspicion to pull you over for a traffic stop. That means they only need to have a lesser amount of evidence to temporarily detain you to see if a crime may be going on. But see, this is where most people get trapped, because police often blur the line. Here's their trick. They'll detain you based upon reasonable suspicion, but then they will fish for probable cause, based on your nervousness, maybe your behavior, something about you they don't like, they think they can add up to probable cause. Speaking of fishing for probable cause, this brings us to probably one of the most abused statements by police officers out in the field during traffic stops. When cops use the smell test, they claim, "I smell marijuana." This phrase has been used for decades as a key to get into your car, because they claim smell equals probable cause. And it's true. That's exactly how that has worked until recently. So now I want to break down specifically, how should you analyze this situation if a cop walks up to you and claims they can search your vehicle because they claim they smell marijuana? I'm giving you 3 big questions you need to ask. You can do the analysis here to determine what sort of situation you're in and exactly what to say if a cop walks up to you. So number 1, is marijuana legal in your state? If it's currently legal, it is very unlikely that police are going to be able to use the smell of burnt or fresh, yeah, there's a difference, burnt or fresh marijuana as a basis to establish probable cause to search your car. And I'll cover some specific examples of states and how they see this here in a minute. But if marijuana is illegal, states like Texas, now there's a much higher probability courts are going to enforce and claim that cops say that when they smell supposedly marijuana, it can be used as probable cause to search your vehicle. For example, in Texas, under current law, it is still a misdemeanor crime subject to a potential arrest if you have any usable amount of marijuana. So if that's your state, if that's your situation, be aware cops are going to use this trick on you over and over again. Question number 2, is the cop, when he pulls you over and starts asking you, saying, "Do you smell that? I think I smell marijuana," does he claim it's burnt, the burnt odor of marijuana, or the fresh smell of marijuana? You say, "Jeff, why does it matter if there's a difference?" Well, let me tell you, the smell of burnt odor of marijuana is a big difference. Because if they're claiming it's burnt marijuana smell, now it's much more difficult for the police officer to tie a burnt odor smell to the actual car. Because someone could have smoked the marijuana from another location and it carried over residually. You could have just been around someone else who has smoked marijuana and now you have this odor about you, but it may not have anything to do with the vehicle. The reality is this. I've rented rental cars that the moment I got into the car, it immediately reeked of marijuana, the burnt odor of marijuana. So the burnt odor of marijuana can linger for days, and in reality, it has very little to do with any potential illegal possession of marijuana. But now, what about cops claiming they smell the odor of fresh marijuana in the car? Now, not that I'm a marijuana expert, but I can tell you this, there's a very distinct difference between the odor of fresh marijuana and maybe stuff that had just recently been cut. You've got seeds and stems, all that's there, and the actual burnt odor of marijuana. If they claim it's fresh odor of marijuana, quite a bit different situation, because now that is usually, courts have ruled, that would be much more easily tied to the use and the possession of it within the vehicle itself. But watch out for this trick. Cops, the good ones, know this. They know that they'll look at it and say, I'm not sure exactly what I want to say here, so let me see if I can get the driver to admit to it. They'll walk up and they'll say, you smell that? What does that smell like to you? And sometimes people, in a moment of hoping that the cop will work with them and maybe he's going to, just cut them loose because it's marijuana, they'll say, yeah, man, I know it's marijuana. So they'll want you to admit that it smells like burnt marijuana or that it smells like fresh marijuana. So now it makes it much easier on the officer because they don't have to prove it. They now have your confession to it. Question number 3, if cops now claim they have probable cause to search your car because of the smell of marijuana, does that now allow them to extend that probable cause to search everyone else in the car? This brings us to the very important 1948 Supreme Court case of United States versus D. Ray. This case was very important because it ruled that just because police officers have probable cause to the driver, it doesn't mean it immediately transfers over that same probable cause to everyone else in the car. So in other words, if cops claim they smell the odor of marijuana in the car, the law will actually categorize the car as a container. And who has possession or control of that container? The driver, not the passengers. So they're going to have to come up with separate, independent probable cause to do anything to anyone else in that car. But let me give you the cop playbook here. The first thing they'll do if they smell marijuana is they'll say they now have probable cause for the driver. So they'll get the driver out of the car and they'll start to talk to the driver to see if they can find anything from him to establish probable cause for the actual passengers. And then another cop will go and talk to the passengers to try to see if they can get them to admit to anything either about the driver or anything else they may know about inside the car. But this is really important. Cops cannot do anything. If everyone exercises their constitutional rights and closes their mouth, there's 2 big problems here. Number 1, there's no separate independent probable cause for any of the other passengers unless someone talks. But secondly, remember, it must be proven that someone exercised care, custody, or control over these so-called drugs. And if there are drugs found in between multiple people within a vehicle, it makes it very difficult to prove intent. You have to know the drugs are there in order for the officer to actually be able to sustain a case against you. Remember, with possession of marijuana, the police and the prosecutor, they don't have to prove ownership. They actually have to prove intent to exercise care, custody, or control. So here's the critical question the cops must answer if you find yourself as a passenger in a car. They have to answer, what separate evidence exists, facts exist, that allow me to believe there's probable cause that a crime is being committed, that this smell of marijuana is in any way associated with these passengers, and if you cannot establish separate probable cause, it would be an illegal detainment and an illegal arrest. Let me be clear, being in the vehicle alone, without any other evidence, is insufficient for the police to claim they have probable cause to pull a passenger out and either detain them or arrest them. So how do cops make this connection and actually establish enough evidence to pull people out of the car, the passengers in the car? Well, here's some of the things. I'm going to give you a list of some of the items they look for. They're looking for behavior. One of those things they're looking for are bloodshot eyes. They're looking to see if there's any signs of intoxication. Number 3, they look for what they call meth mouth, missing hair. They're looking for burnt fingertips, burnt lips, anything that would indicate active drug abuse in someone's life. Cops are looking for active evidence to create a profile of a drug user, but they must articulate specific facts establishing this. Otherwise, they don't have enough to do anything to the passengers in the car. That being said, I dealt with a case one time where the driver actually panicked during the traffic stop and quickly tried to shove his bag of marijuana under The passenger seat, of course, there was a guy sitting there, his friend, and the police saw him making this quick furtive movement, and now that gave them all the evidence they needed, in addition to the smell of marijuana, to not only get the driver out of the car, but they could get all the passengers out of the car, and everybody was able to be searched because now there was movement associated not just with the driver, but also with a potential passenger. Now, let's look at some specific states where they've made some changes to their laws so that you know where you stand. How do we really know if the news we are reading is unbiased and fair? With competing narratives, media bias, and big tech censorship, cutting through the noise to see what's really happening isn't always easy. Luckily, there is a solution. Ground News gives you the freedom to discover whether what you are reading is unbiased and fair so that you can come to your own conclusions. Isn't that what the news is supposed to be about? Check them out for yourself at ground.news/Hampton. Let's take the recent decision by the U.S. Department of Justice to abandon police reform settlements with Minneapolis and Louisville. Agreements that were initiated after the death of George Floyd and Breonna Taylor. As we analyze the coverage, the top right displays key details: the number of sources reporting, their political bias distribution, reliability ratings, and ownership information. These insights help reveal how different outlets are shaping the narrative. One of the most powerful features of Ground News is the headline comparison. Here we can see for ourselves how stories are being framed by different news outlets. By clicking on the left, center, and right, we can observe the language and tone used, allowing us to draw our own conclusions. For instance, a left-leaning headline might focus on civil rights implications, while a right-leaning headline might emphasize federal overreach concerns. My favorite feature, though, is the blind spot feed. With blind spot, you can see news stories that are being disproportionately covered by one side of the political spectrum. In our polarized environment, I have found this feature to be an amazing resource to discover news stories that I might have missed otherwise because only one side was talking about it. It's perfect for better understanding friends and family who think differently. The best part? Ground News has a special offer for all of my viewers. If you sign up through my link, you'll get 40% off the Vantage plan, the same plan I use to get unlimited access to all their features. Go to ground.news/Hampton to give it a try yourself. Click the link down in the description or scan the QR code to stay better informed and transform the way you read the news. The state of Maryland. In 2020, courts ruled that the odor of marijuana is not enough evidence to search a person. And as of 2023, a smell and odor of marijuana is no longer enough to search a car either. But what if an officer continues? Maybe they don't know the law and they still demand to be able to search your car. You can say, "Officer, I'm aware that odor alone is not enough to establish probable cause for a search. Therefore, I do not consent to a search of my vehicle." What about Colorado? In 2019, courts ruled that drug-sniffing dogs that are trained to hit and alert on marijuana cannot use that hit for marijuana as evidence to establish probable cause unless they have some additional evidence. Ohio, since recreational legalization in 2023, the smell of marijuana alone is insufficient for probable cause. So, what we see now in Ohio is that police officers are now looking for evidence of impairment in order to allow them to fish for that probable cause. Florida and Texas, watch out. These two states still penalize and criminalize the possession of marijuana, so as a result of that, cops are using the claim that they smell the burnt odor of marijuana or fresh marijuana as a reason to get in your vehicle. But remember, if you're in a state where hemp is legal, it's indistinguishable, the smell, between burnt hemp and actual burnt marijuana. Regardless of whether marijuana is legal in your state, the best practice is to always refuse consent to search. Don't just hand over the keys to your car to a police officer. Think of the odor of marijuana as the police version of "I have a hunch," but more powerful because there's no way to verify that claim in the moment. You can record police officers, you can do the audio and the video, but there's nothing there to actually hold the officer accountable as to whether or not there was an actual odor. So if smell of marijuana is not enough in many states, how are police still getting away with this? Loophole number one, the pretext stop. The important Supreme Court case of Wren versus United States established that cops can follow you around, look for a ticky-tack traffic violation, use that as a reason to pull you over and try to investigate you. And even if they didn't care or want to write you a ticket, the Supreme Court said it's okay if their main goal was drug enforcement. So what can you do to combat this? Always signal your turn, Always keep your vehicle legal, and know that if they're pulling you over and it feels like you didn't do much of anything wrong, they're really fishing for more. And the best way to stop a pretext stop is that if an officer starts to look to write you a ticket, always exercise your right to remain silent. You don't have to say anything, and as soon as he hands you a ticket, say, "Am I free to leave or am I being detained?" The moment the officer hands you that ticket, the reason for the stop is over and legally you are allowed to leave. If the officer wants to hold you longer, he must have separate legal basis to do so. Loophole number 2, I'm holding the car for a canine unit. The Supreme Court case of Rodriguez versus United States laid it out very clearly that cops cannot prolong a traffic stop beyond the original reason they pulled you over. So in other words, if they're going to hold you longer than the time it takes to write you the ticket for speeding or for not using your turn signal, they're going to have independent, separate reasonable suspicion or separate probable cause to either search or hold you. The best way to handle this, to stop cops, is keep asking the officer, "Officer, am I free to go or am I being detained?" If the officer says you're free, get out of there. If he says you're being detained, exercise your constitutional rights, your Fifth Amendment right to remain silent, and your Sixth Amendment right to have an attorney present if he's going to keep talking. And then perhaps the most powerful loophole in all of law enforcement, if cops can get you to consent, consent cures all, they can search everything. The golden rule, no matter how you feel in the moment, no matter how intimidating it may be, is to memorize the phrase, "I refuse consent to search." That's all you have to say, and then don't say another word. Giving consent to cops is like inviting someone into your house to look around and then being shocked that they start opening all of your drawers. But even when you don't consent, cops can sometimes find another way in when they claim you are making furtive movements. We've all seen it before. Cops walk up to someone's window during a traffic stop, and immediately they start thinking someone looks nervous, or maybe they made a quick movement that now puts the officer in fear of their safety. But what does the law actually say about this? Well, the two most common behavioral indicators cops are looking for are nervousness and furtive movements. A furtive movement, what is that? This would be considered by the cops a sudden or suspicious movement, like ducking down, reaching for something, or grabbing, moving very quickly. The good news, courts across the country, even in states like California and Texas, have said that furtive movements alone, in most situations, do not establish probable cause. In Gonzalez versus State, the Texas court ruled that a, quote, furtive gesture without more was not sufficient to justify a search. Furtive movements is like accusing someone of cheating because they just looked away for a second. Suspicious? I mean, maybe, but proof? Definitely not. If you are accused of making furtive movements, the first thing you need to do is raise your hands up and say, "Officer, I didn't reach for anything, and I'm in compliance, but I do not consent to a search." What about nervousness? Who wouldn't be nervous during a traffic stop? In United States versus Milan, the court ruled that being nervous is not a reliable indicator of criminal behavior. Now, police likely know this, but they still use it anyway because they know you don't know the law. And here's the key. They know that if you don't know the law and they start acting and accusing you of being nervous or making furtive movements, you'll make more mistakes, and the more mistakes they can stack on each other, the better the chance they have probable cause to search. If the officer accuses you of being nervous, you can say simply, "Officer, I'm trying to remain calm. I do not consent to any search." But let's say they ignore you being calm. They ignore your words, and they search you anyway. What then? Here are the exact steps you can take. Number 1, stay calm, don't make any quick movements, and record everything. Remember, no quick movements. If you have to, turn off the car. You need to roll down the window if the officer's forcing you to go that direction. But remain calm and record the officers. It is absolutely your right to record police encounters. Number 2, provide your state's required documentation. License, proof of registration, and insurance. That's it. Don't do anything else. If the officer starts demanding more, starts wanting to ask you more questions, "Officer, I exercise my right to remain silent. I will not say anything else unless my attorney is present." Step number 3, never consent. The cops may look in and start digging in, shining their flashlight in your back window, saying, "Hey, mind if I take a look?" Don't fall for it. Always say, "Officer, with all due respect, I refuse consent to search. Am I being detained? And finally, number 4, if the officer just gives you a warning or actually writes you a ticket, but they continue to hold you on the side of the road, they're probably waiting to either get a drug dog or they're trying to wait for you to slip up. So that's when you say, officer, am I free to go or am I being detained? If you're free to go, get out of there. If you're being detained, lock it down. Your 5th and 6th Amendment rights, do not say anything. Exercise that right to remain silent and exercise your right to a lawyer. But what if instead of pulling you over, officers come to your front door and they start banging on your door, yelling, claiming they can smell marijuana from the front porch? You really have 2 choices here. Number 1, you can absolutely ignore them. Because if they don't have a warrant, they can't do anything about it. They cannot come into your house. And if they do have a warrant, they're probably not going to tell you. They're coming in anyway. But if you choose to speak to them, whatever you do not open the door. You can talk with your door closed, and you would ask them, officer, do you have a warrant? And if they say no, that's it, pound sand. If they say they do, you need to ask to be able to review the warrant. Either it's through, they could slip it through if you have a window on your door, or they could slip it under the door. But what about the old trick? We don't have a warrant, but if you don't cooperate, this will get a lot worse for you. This is an old lie and trick cops have used for years. In that situation, you can say, I'm invoking my 4th Amendment rights. The only way I'm opening this door is if you come back with a warrant. But what if you're not in your car or at your home, but you're just walking down the road and a cop walks up and claims they smell marijuana? Understand, if a cop just walks up to you and you're just walking down the road, this is what's labeled a consensual encounter. You can literally ignore the police officer. He has no right to hold you or detain you. Now, if he tries to get in front of you and stop you, the number 1 thing you've got to ask is, am I being detained or am I free to go? If he says, no, you're not being detained, but why won't you talk to me, man? I mean, you got nothing to hide. Let's just have a little conversation. You don't even have to answer him. You can just continue to walk away because under the Constitution, the officer has no legal basis to treat you like any other stranger. You can literally ignore them. But what if the cop now says, yes, you are detained? Now we move to step 2. Immediately, if the officer is wanting to get into your pockets to search you, you politely refuse consent to search. It is so important that you say the words, I do not consent to a search. Because if the cop ignores that and tries to search you anyway, you will have legal standing when you get to court to challenge the legality of that search to have the entire thing thrown out. Finally, number 3, and this is the hardest for many people, if the officer ignores everything about your rights, remain calm and invoke your rights. This is so critical because when an officer is not following the law, it's easy to want to lash out and get upset. But instead, remain calm, exercise your right to remain silent, your right to an attorney, because if you elevate the situation, the officer will now use this as an excuse to claim you're resisting arrest or maybe somehow assaulted a public servant. So remember, never consent to searches. Always ask if you're being detained or if you're free to go. And always exercise your right to remain silent and your right to a lawyer. Now, we just covered the exact steps you could take to protect yourself and stop cops when they claim they smell marijuana. But what if cops start trying to pull tricks on you and lie to you? Did you know cops can legally lie to you? Check out this next video where I break down the 10 lies police love to use and how you can stop them. See you over there.